Hi, I'm Elizabeth Gearhart. I'm sitting here with James Klobucar, patent attorney at Gearhart Law. And we're going to talk about design patents and the advantages and disadvantages when you compare them to utility patents. So, James, first of all, what is a design patent?
So a design patent is a patent that protects the ornamental appearance of an item. An example I give people a lot is, the classic ballpoint pen that you click the stylus. It has a spring in it. It has, the ink. It has the general out fixture of a pen. But you have a lot of different pens, right? They all look a little different. And that's really what a design patent protects. You're not going to protect the actual item itself per se, but you're protecting the outward appearance of it. The idea is that the design is devoid of functionality.
I see. So, in the case of a pen, you might want to get a design patent and a utility patent if you could, both, right?
Yeah, I mean, if you can certainly go for both. Some people will do one or the other. It really depends on the nature of the invention, the outcome of the patent search, and what it is you're trying to protect and what the invention really is.
So, is it easier to get a design patent than a utility patent typically?
Generally, yes. Most patent applications, filed as a design application are going to go right through to allowance.
Okay.
Oftentimes with the utility application, you have to do a bit of back and forth with the patent office in order to get it allowed. But that being said, each one has its own quirks and nuances. Even though a design application may appear simple because it's mainly, comprised of drawings, they're still really easy to get wrong. And if you get them wrong, they're much harder to correct than a utility patent. So it's really important that you do it all right from the outset.
Okay, so if you had something that you wanted to protect, but you couldn't get a utility patent because, like you said, a pen has been around forever, then you maybe could get a design patent on how it looks.
Correct. Mm-hmm.
And so you'd have some protection from competitors.
Right.
So then, what's the difference in price between a design patent and a utility patent?
It's going to depend a little bit on how many embodiments or how many versions of the designs you want to protect and how you want to do it. The drawings are going to make up the bulk of the costs for the design application. But typically from start to finish for a utility application, you're going to be looking at around $10,000 to $15,000, potentially more depending on the complexity of your invention. And then you have to worry about maintenance fees after the patent is issued. So at 3.5, 7.5, and 11.5 years after issuance, you have to pay a maintenance fee. For design applications, typically you're going to be looking at probably around $2,500 to $3,000, start to finish. Wow. And there's no maintenance fees after the issuance. It's a 15-year patent term, and you get that regardless of what you do going forward.
Okay, so there are a lot of advantages.
Certainly. And I think one point worth mentioning is that in terms of patent infringement, they have provisions that allow you to go after different forms of monetary damages for design applications, which can end up equating to considerably more than you would get under like the reasonable royalty type standard for utility application. It's one of the reasons why, if you follow like the Apple and Samsung with what they call the smartphone wars, the initial kind of $1 billion verdicts that came out there were largely based, probably about 70% or so of that initial award was based off of design patents.
Wow, so not as expensive to get, but certainly powerful.
They can be, yes.
Yeah.
Yes, quite.
But they only protect so much, so I think the disadvantage is they don't protect as much as the utility patent protects, right?
Yeah, I mean, that's going to vary. I mean, a lot of people will hold that train of thought in that, design patents, protect something much narrower than a utility patent. And to some extent that can be true, but it also depends on how novel of a design you have and, what it is that you claim as part of your design. So there are ways, for example, just taking this, cup in front of us, it has a cat inside.
I know, I bought these cups.
But that being said, I mean, you could do a design patent on this entire cup, including the cat, or maybe you just do the cat And
Okay.
anyone who makes any cup that has this type of a cat or a similar cat in it may run afoul of your patent, regardless of what the cup looks like. So depending
Okay.
on how you segment certain portions of the design off and other, drafting techniques, it can become quite valuable, and you can protect, little small parts that may be, unique, and really go after people that want to implement that in a particular fashion.
So design patents, even though they're not as expensive, they actually do have a lot of value.
They do. They really do, yes.
And
I mean, you
often,
shouldn't discredit them by any means.
no, and oftentimes I think people with the money will have both design and utility patents in their portfolio, right?
Right.
So, and investors like that. Well, great. This has been really elucidating. Thank you,
Good,
James.
good. I appreciate it.
So, how can people find you?
They can find me by calling the firm general contact number, or they can reach out, via email. Either way is a good way to get a hold of me.
Great. Well, thank you. This is James Klobucar of Gearhart Law, and we were just discussing design patents.
Thanks.